Well, welcome everyone. I'm pleased that we have so many people here with us today, both in our own local Washington, D.C. region and around the country. My name is Harvey Ryder, and I'm a past president and current board member of the Jewish Community Relations Council of Greater Washington and a member of the Tzedek D.C. Advisory Council. On behalf of the JCRC, I want to thank our brown bag lunch. And when I say brown bag lunch, it used to be in person. Our brown bag lunch co-sponsored Tzedek DC, the Jewish Federation of Greater Washington, the American Jewish Committee, and the Association of Jewish Lawyers and Jurists. And a special thanks today to our additional partner for the program today, the Combat Antisemitism Movement. Our discussion today on the law and anti-Semitism poignantly coincides with Yom HaShoah, the day of Holocaust remembrance and mourning on the Jewish calendar. Several hours ago, in fact, the entirety of the state of Israel came to a standstill for 2 full minutes as sirens blared in memory of the 6 million Jews murdered during the Holocaust. Yet even as we mourn, reflect, and commit to preserving the legacy of those we lost and those who survived, we're keenly aware that anti-Semitism is alive and flourishing here in our midst and worldwide. Holocaust commemoration education is a year-round priority for the JCRC, reflected in JCRC's extensive work with local school systems, state and local advocacy on behalf of Holocaust survivors, and more. Over the next 2 weeks alone, the JCRC is sponsoring a wide range of Yom HaShoah-related programming, both virtual and in person, that will reach thousands of people. Our virtual community-wide commemoration is going to take place this Sunday at 1 o'clock Eastern Time. And we'll also have other opportunities to hear from survivors themselves and their children and grandchildren. We invite you to join us for one or more of these opportunities, and the details can be found on the JCRC website, www.jcouncil.org. And I think we'll also be able to post the relevant links in the chat. May the memory of the 6 million be a blessing. I do want to make a couple notes here. This program is being recorded and it'll be available if you know people who couldn't attend and want to watch it later, they'll be able to do so. And we also have live closed captioning for those of you who wanted or could use it. It's now my pleasure to turn the program over to my colleague, Ariel Levinson-Waldman, the founding president of Tzedek DC.
Thanks, Harvey. Thank you to the JCRC. Thank you to the AAJLJ. Thank you to Federation, our Young Leaders Program. Thank you to all of our sponsors. Thank you to everyone for being here on this day, an incredibly important day in our Jewish community, Yom HaShoah, to talk about a topic that is always important, but especially in recent years has emerged as centrally important here in the United States in the 21st century. Anti-Semitism, what can the law do about it? I am grateful to Rob Katz, who we're going to hear from today, for being a thought leader on this. This topic on this week of all weeks has particular resonance for so many of us. For me, this is the first year that we'll be having our children hear the names at the Yom HaShoah reading. They're just now old enough that we think they're able to begin grappling with the topic. I am only able to be here and to do anything at all with this life and share these words as a result of absolute miracles and my Savta surviving the Shoah. 127 members of our family did not. And it is remarkable and disturbing and difficult that we have to have these conversations at such a serious level in the United States of America in 2022. There are so many different ways one could quantify the challenges here. I'll just note one from a report that the Anti-Defamation League issued very recently, in which we see 100+% spikes in anti-Semitic incidents in DC, in Maryland, over 70% in Virginia. And these issues, of course, for the last half decade at least, have been spiking around the country. And it has not stopped with the end of the Trump presidency. We are fortunate that in Rob, we have someone who is exquisitely positioned and credentialed to be a thought leader and an organizer and a convener in this space. Professor Robert Katz is a professor of law at the John S. Grimes Fellow at Indiana University McKinney School of Law. After going to extraordinary colleges and law schools, Rob served as a law clerk to then Judge Breyer on the Court of Appeals for the First Circuit. Of course, later Stephen Breyer became a Supreme Court justice of great renown for 2+ decades and has been in the news recently. And before becoming a law professor over 20 years ago, Rob was a teaching fellow at the University of Chicago Law School, which I have a little bit of a special feeling about that because one of Rob's students was my wife, Rachel, who remembers that experience fondly. And Rob also had an unusual path in some respects. He spent a period of time as the director of the Harold Grinspoon Foundation, which many of you will know for Jewish community involvement, including of PJ Library fame. We are in fact are a PJ Library family, so thank you, Rob, there as well. Rob is also a trial attorney at the DOJ, the Civil Division, and his scholarship for the last 20 years has covered law, religion, the First Amendment, nonprofit organization, trust and estates, civil rights, social enterprise. So I am grateful to you, Rob, for your work and leadership, much needed leadership in this emerging area of American law. And we turn it over to you. And thank you and welcome.
Extraordinarily kind. Thank you, Ariel. Can I spend the next 5 minutes talking, saying nice things about you, or should I just cut into my talk?
Only if there's rebuttal opportunities.
Okay. All right. Well, good afternoon, everyone. In spring 2021, I decided that I wanted to teach a course that explored the intersection of anti-Semitism and the law. My first step was to find a casebook on the subject. You would not believe how many casebooks I found. 0, none, zilch, nada. I told you wouldn't believe me. So then I went in search of a center for the study of anti-Semitism and the law so I could ask them to send me sample syllabi. I soon found out that such a center was merely a figment of my imagination, which explains why they never called me back. Undeterred, I went in search of a law school that offered the course so I could ask a professor to borrow their syllabus. After searching the course offerings at dozens of law schools, I found that none offered it. Not only that, they assigned it 0 credits. Having run out of easy options, I decided to create the course myself by drawing upon the body of research that systematically studies the intersection of anti-Semitism and the law. But my research revealed only that no such body of research exists. So began my ambition to become a scholar and a teacher of anti-Semitism and the law. I had no choice but to write upon a tabula rasa, which, as you know, is Latin for garnished. Let me cut now. So, okay. Virtually every law school in the country offers at least one, excuse me. To be fair, there's an entire genre of legal scholarship known as outsider jurisprudence. It includes the study of law and race, law and gender, law and sexual orientation, law and indigenous peoples, law and disability, law and poverty, law and immigration status, law of incarceration, and so forth. There is at least one casebook in each of these fields. In several of these areas, there are multiple casebooks reflecting different approaches, politics, and schools of thought. Virtually every law school in the country offers at least one course in each of these fields every year, and multiple courses in several. Dozens of law schools run centers devoted to the study of law and race, law and gender, and so forth. These centers are critical to the development and vibrancy of these fields. They host lectures and symposia, support research, publish journals and studies, offer courses, collect syllabi, engage practitioners, and operate clinics that train students how to defend the rights of people discriminated against on the basis of their outsider status. Virtually nothing like this exists for anti-Semitism in the law. Most universities have departments, many for Jewish studies, many have centers devoted to Holocaust studies. Several law schools offer courses on Jewish religious law in its comparative aspects, but anti-Semitism in the law, there is nothing. It's more than ironic that Jews, the quintessential outsiders, are outside the scope of this scholarship. It's also perplexing. There is no shortage of Jewish law professors, Jewish law students, and Jewish donors, and sadly, no shortage of anti-Semitism. How did this escape notice? Well, it came to my notice, and I decided to do something about it. And one of the first things I did was I contacted my colleague and college classmate and friend, Professor Diane Klein, who's on the call. She saw what I saw, or rather, she saw what I didn't see, and she also saw the opportunity. We decided to found a 501c3 nonprofit, the Law versus Anti-Semitism Project, to serve as our platform and as the nucleus for a future center. We formulated a mission statement to promote research and teaching at the intersection of anti-Semitism and the law. We devised a plan for advancing this mission. We would start by convening a conference and producing a casebook. For the rest of this presentation, I'll say more about the project's mission, its plan of action, and its accomplishments to date. Then I'd like to open up to questions and seek your thoughts on how to raise it to the next level.
Bob, just a quick technical note. I think some folks in the audience are not able to see the presentation if you have a slide up. We can see you, just not the presentation.
Oh, okay.
Try to stop, stop sharing and then reshare and see if that fixes it.
Okay.
There we go.
Okay. I'm sorry.
Working now.
Right. These are all the casebooks,
Beautiful.
which reflect the courses and the centers and so forth. So this is the project. And our first undertaking was to organize a major legal academic conference whose goal would be to convene the relatively few and isolated scholars currently doing research at the intersection of anti-Semitism and the law, provide an outlet for their research, and create a community of scholars who see themselves as part of a larger scholarly undertaking. Initially, we wondered if anyone would come. We wondered if anyone would want to present. We needn't have worried. After 9 months of gestation, the inaugural Law versus Anti-Semitism conference took place at Indiana University, McKinney School of Law on March 14th and 15th, 2022, both in person and virtually. It was more successful than we had thought possible. Most remarkably, everything started on time and didn't run over. We had over 50 individuals presented, including law professors, political scientists, historians, Jewish studies scholars, practitioners, judges, think tank leaders, rabbis, community leaders, and artists. Presenters came virtually from 20 states, plus Israel, England, Germany, Austria, and Luxembourg. More than 200 people attended, including law students, lawyers earning CLE credit, and academics worldwide. Selected papers from the conference will be published in the Indiana Journal of Law and Social Equity. To our knowledge, the first such collection of its kind. The richness of the conference was reflected in the titles and the plenaries. These included post-Holocaust litigation and reparations, Jews in the legal profession, hate speech and the First Amendment, Jews and adoption law, legal responses to anti-Semitism on campus, Christian supremacy and the religion clauses, critical race theory and anti-Semitism, and using state law to combat anti-Semitism. What, you may ask, can a mere conference do to stimulate the creation of a new field of legal study? Well, consider the fact that 3 cutting-edge fields were hatched at conferences: critical legal studies in 1977 in Madison, Wisconsin, critical race theory, also in Madison in 1990, and Latinx critical theory in San Juan, Puerto Rico in 1995. So there's precedent. What, you may ask, can a mere conference do to make the world safer for Jews? Well, consider the fact that a man named Theodor Herzl once issued a call for papers to stimulate discussion about anti-Semitism and search for solutions. That conference, held in Basel, Switzerland in 1897, made a difference. So the conference at IU was not a one-off. 3 institutions have now lined up to host future law versus anti-Semitism conferences. Lewis and Clark Law School in Oregon for 2023, Florida International University College of Law in Miami for 2024, and Sheffield Hallam University in Sheffield, England for 2025. We have also proposed a discussion panel on the topic at the 2023 annual meeting of the AALS, the Association of American Law Schools, which will also be the first of its kind at that meeting. Clearly, we've started something. If there wasn't a there before, there is now. Our next project is to begin a casebook entitled Jews, Anti-Semitism on the Law. And I've begun working on the casebook with Professor Klein and Professor David Schraub, who we actually incidentally met on the set of Gentleman's Agreement, for which Diane won an Oscar for Best Supporting Actress. Congratulations, Diane. This is the casebook, our cover. A casebook is critical to developing this field in 2 ways. First, few professors have the energy or motivation to create a course from scratch. A casebook is a huge labor-saving device for any professor. It is especially important for junior faculty who have to focus their energy on publishing articles. Second, even if a professor is interested in teaching a new course, they have to persuade their colleagues and deans that it's worthy of being taught. There is simply nothing like a casebook to lend legitimacy to a field of study, to announce to the world, this is a thing. If you build it, they will come. Every law school is committed to diversity and inclusion. They operationalize it in part by offering courses on the law and outsiders, with one glaring exception. Once the case is made for the legitimacy and importance of anti-Semitism in the law as a field of study, and the casebook is critical to making that case, we believe that many and hopefully most law schools will want to offer it. We hope that law schools around the country will adopt the casebook for an upper level elective. Portions of the casebook could also be used to supplementing existing courses on the First Amendment, law and religion, anti-discrimination law, and others. There is right now very heated discussion within and outside the Jewish community concerning anti-Semitism. What is it? Why is it? What to do about it? What do we already know or think we know? What avenues haven't been pursued and have, and with what success? Our knowledge and experience here is disparate and disorganized. This is especially distressing for tidy law professors and lawyers. We have a plan for organizing the study of anti-Semitism as a legal phenomenon. We start with the premises that the American legal system gives a privileged place to white Christian identity, and that Jews, the non-Christian, not quite white minority par excellence, are legally vulnerable, and especially so. We have identified 4 key questions for diving into this material. First, how does the law privilege white Christian identity? Second, how have American Jews historically tried to use law to achieve equality and safety while at the same time flourishing as Jews? Third, historically, how have these methods succeeded? And lastly, how can American Jews today use law to achieve safety, equality, and flourishing moving forward. This gives us 4 recurring themes throughout the casebook, and that we think will animate this as a scholarly field. Responding to white Christian identity, achieving equality for Jews, achieving safety from anti-Semitism, and using the law to promote Jewish flourishing. Which leads us with our central claims that 1, this is a worthwhile intellectual endeavor, that the systematic study of these questions will yield new and unique insights about American law and the American Jewish experience, and that this study will have a practical payoff. It will yield new and valuable insights into how to use law to combat anti-Semitism. So now I am proud to say that this field of study is greater than garnished. We have and will have conferences, we have a team, we have a mission, we have a plan, and now we have hopefully all of you. So let me stop my presentation and turn it to the audience to ask, what are your ideas? What are your questions? What is your input? So Ariel, the floor is open.
And thank you so much, Rob. I know that folks are going to begin formulating questions in the chat. Just to jumpstart the Q&A, I suppose I want to raise 2 related questions for you to reflect on. One is, you gave us a little on this, but how did you get here? How did you begin to focus, begin to motivate after, decades of thinking about a whole range of things?
Right.
And then second, you mentioned the plan. I suspect I'm not the only one interested in hearing more about the plan. What is the short-term plan? How can people get involved and help make it happen? And what is the long-term vision for what this could look like and what the impact could be?
So, well, I was inspired by many things. Of course, anti-Semitism, including anti-Semitism that I personally experienced. But I think it really turned on negative feedback on my teaching from colleagues and students. So let me explain. So in every course I teach, as do many professors, I try to show how the law imposes special burdens on outsider groups like African Americans and women and members of the LGBT community. So in my view, it's relevant, it's important, and students appreciate it. So a few years ago, I decided to start including coverage of the special burdens the law imposes on Jews. And when I told a colleague about this, he advised me that I should warn students in advance that I'd be doing this, that I basically should revise the course descriptions to say something like, oh, and we will be including discussion of Jews. He thought that if I didn't do this, students would be not just surprised, but annoyed. This made no sense to me. I don't warn students in advance that I'm going to be talking about the law's impact on African Americans and gender. And so I ignored him, and I went about and I did exactly what I said. And turns out that he was exactly correct. I got I looked at my student evaluations, and I had comments from students saying like, oh, Professor Katz talked about Jews and anti-Semitism every class, and it was irrelevant, which of course wasn't true. I discussed it less than I did the others, and it was entirely relevant, but it showed that it was uniquely unwelcome. And so I said, well, if this student is complaining that I'm talking about Jews and anti-Semitism in every class, maybe I should have a course where I talk about Jews and anti-Semitism in every class, because clearly, it's not being covered. And I saw that. I said, look, I'm a tenured faculty member, and if I'm getting advice from colleagues not to talk about Jewish stuff and anti-Semitism, there's a problem here. And I I noticed that there was a problem. I mean, I could start detailing the problem, but I said, this will not stand. And I decided that it was, and I looked at the cases the courses that my law school offers, and it's like, 3 on race and 3 on gender. And I was like, there's nothing here there. There's nothing on Jews. Jews were invisible. Jews not in my school. Jews not just invisible, in the curriculum. They're invisible. There are only a handful of Jews in the school. Jews are absent from the consciousness. So, for example, they organized the annual diversity dinner on the first night of Passover, and only changed it when I objected. I mentioned that I had my own experiences with anti-Semitism, and this is something I looked into, and it turns out that today we would call these microaggressions. People do things sometimes subconsciously that sort of that are jarring, that reflect bias, and so I looked into the literature on microaggressions, and it turns out that there is no literature on microaggressions involving Jews. If you go to the website of my university's DEI, Diversity, Equity, and Inclusion Office, they have a page and a half of articles on microaggressions on every outsider group you can imagine. So, I just noticed that there was no, it just, once you see something, once you notice something is missing, there's a dog that's not barking, it becomes deafening. And that's really where I am. And so I said, I've got to stop whatever else I'm doing and make this, no one else is doing this. I'm going to have to be the one. And fortunately, I have Professor Klein, who has joined me in this, who understands exactly, has had similar experiences. She totally gets it. And she's as energetic a person as you could find. And we found another colleague, Professor David Traub, and we're gonna make this happen.
And if I can add to that a little bit, Rob and I are, of course, longtime friends and also in the same line of work. And so we've had lots of conversations on many subjects over the years. But part of what brought us together, I think, in this project, I come at it from a different background in legal teaching. I'm an anti-discrimination law teacher. I am a critical race theory person. And I felt like in the contemporary environment, there was a lot of conversation about the connection between anti-Semitism and critical race theory that was woefully underinformed on both sides. And part of the project, from my point of view, and one of the reasons why I think Rob and I have been able to work fruitfully together, is that we see many of these issues quite differently. And at the same time, it's important to us that this be an academic and not a partisan project. And that was true for our conference. It will be true for our casebook. And that means that our conference included presentations by people with whom I profoundly disagree, and the same for Rob. And our casebook will include materials that come from points of view very different from our own. That is an important part of our project, is to raise the level of civil, academic, well-informed discourse on these subjects, many of which divide the American Jewish community quite deeply. And we are not going to have people open a book, read one thing in it and say, oh, okay, they're on that side, I'm done, right? And the same went for the conference. And that meant many difficult conversations about who could and couldn't present at the conference, who would and wouldn't be there, who would and wouldn't sponsor it, and all the rest of that. But we're pretty committed to trying to find a way to negotiate through that, right? To find and to build some common ground that is well-informed and that has room for people, who, for example, might find themselves on opposite sides of the current case that I think was argued just this week, the praying football coach. There are people in the Jewish community, and including in the legal community, who are advocating for his free exercise rights, and people who regard a victory by his side as a triumph of Christian supremacy in American law. From one point of view, they can't both be right, but there is a fruitful conversation to be had. And this is a perfect example of a case we will include with commentary from both sides, right? It is absolutely, what is clear to us is that the right view of any of these issues is not at all clear. This is definitely a 2 Jews, 3 opinions kind of situation, and we intend to reflect that in our conference, in our project, in our casebook.
And 3 Jews, and God only knows how many opinions. I see the question, the premise that the legal system favors white Christian identity. So, I mean, this is baked in from the beginning of Jews couldn't hold office, that they couldn't, testify because they wouldn't swear on the New Testament. Sabbath being on Sunday, in public schools, starting the day with Protestant prayer and hymns. And just in a host of ways. But a lot, I'm focusing especially on the Establishment Clause. And basically, when we mean establishment, we are one of the great, incomplete but heading there, victories of American Jewish Legal Committee, actually Congress and Committee too, was disestablishing, Christian Protestantism in public schools. That actually was a hard-won fight, and rearguard actions all the time, including the, potentially with the praying coach. So Ariel, did you want to ask more questions?
Well, you and thank you also, Professor Klein, for the reflections on how we got here. I wonder if you wanted to share a little more on where things are headed, what this looks like structurally, how folks can get involved, and sort of a little bit on the short, medium, and long-term pieces of the vision, and where the impact might be felt in various important places.
Well,
I'm also seeing some new questions in the chat following that discussion.
You see the screen here? Do you see this?
Yes, I can. I believe everybody on the
Right.
on this.
Right. So this is the YNH Center for the Study of Jews, Antisemitism Law. YNH standing for Your Name Here. So, right now it's just me and Diane and David. Actually, our friend Ken Marcus is actually working on developing a course. So we have people, who understand what we're doing. The next level is really to create a center, to do all the things that I said before, to sponsor lectures and symposia, to support research, to give scholars, including myself, Diane, David, the time to work on the casebook, more time, because it's hard. We're working on this thing. It's just a question of how long it'll take us, and so we have, teaching 2-3 credit courses, it just slows it down. So, so people who could support our research, that would get us the casebook sooner. But a center, would put this on the map, this field, with journals, courses, syllabi. So people who want to teach this course, in between now and when we finish the casebook, we can have syllabi, for them to use. We'd like to start a legal clinic to train the next generation of lawyers who know how to use law to fight anti-Semitism. We want to center as the conference would be a place for practitioners to engage with lawyers. We had lawyers getting CLE credit, learning about anti-Semitism. This needs to become a field. It needs to do what Diane and I have already started doing, conferences and a casebook, but it needs a center. It needs a center, and it needs resources. That's what it needs.
And what I would say about some of the short-term activities and things that people who are on this call might be able to help us move forward is, if you are anywhere a member of a bar association that sponsors CLE events, we can present, an hour, 2 hours, 3 hours. We could do it over a series, right? Most states it's my understanding, have anti-bias requirements for CLE. This kind of presentation that we can do as law professors will almost certainly satisfy that. So getting that on the schedule of CLE presentations sponsored by any state, local, or special interest bar association, that's something we would love to do. And similarly, continuing education or adult education in other settings that you might be part of. I mean, we've all become much more sophisticated about these virtual presentations. So if you belong to a Jewish community center where an hour or 2 hours or a series would be of interest to its constituency, right? We can work that into our schedule as well, right? We're trying to build some sense of this as a field, and that's a two-way process, right? Getting a sense of what people are interested in learning about, anti-Semitism they're experiencing or that occurs in their communities, and thinking about ways of responding to it legally. That's the process, and we're hoping to present to a casebook publisher a formal presentation. We've already been in conversations with some of the upper division adoption editors at leading casebook publishers about this, but the process of creating a casebook is going to take a couple of years, even if we could be doing nothing but this, and of course we're not doing nothing but this. But evolving towards that by offering the material to lawyers, judges, people with an interest in it, all of that moves the project forward. And we could do this virtually. We could do it as in-person guests, depending on where you're located and resources, et cetera.
I just want to lift up something that Harvey Ryder mentioned in the chat for folks that are listening and not speaking. If you can make every effort to be on mute so we can hear Professor Katz and Professor Klein, much appreciated. It looks like there are some additional questions in the chat, and Rob, I don't know if you want to take a chance, take a look at them, or we can try and have them read.
Yeah, I'm happy to go through some of those if you want.
Turn it over to you, Harvey. Thank you.
Sure. So Rob, I wanted to follow up on one of the points you made about establishing a center and clinics. I assume that clinics will be opportunities for students to work on cases, but what about your center as a resource for lawyers who are practitioners who want to volunteer? One of the things that we see in the pro bono world is that lawyers, will venture out into fields that they're not comfortable with, but only because they have the availability of resources, whether it's training or mentorships or a combination of those things, so they feel confident enough that they can help out. And if they feel like they're trying to tackle more than they're comfortable with, they have somebody to fall back onto for advice. You mentioned your conference with a whole range of speakers. Could they potentially be mentors?
Well, I mean, that's an excellent point. I mean, as I in my list of things that that centers do, one of them is like career counseling. So you have students who say, "Oh, I want to work in this field," and we connect them, with, "Oh, then here you want to talk to this person, you want to talk to that organization." So it's a pipeline of getting students who are interested and trained to the right places. So, and in terms of the collaboration on things that litigators can learn from professors and vice versa, I know firsthand because I'm also a litigator. And so I was telling you, I did a case on inmate rights, and then I learned a ton, and then I wrote an article about it. So I mean, that was just me talking to myself, but I can learn from people who are litigating in this field to clue me into developments that I should, that might warrant scholarly inquiry, right? I mean, that's how scholars, in a field like law would know what, the hot topics or issues that really you need law professors to look into. So there's things that law professors and scholars learn from practitioners, and then of course it would go the other way. I mean, if you hopefully, our goal would be developing the theories and the resources that people could be using to identify new causes of action, to support, support claims. I mean, that's why, when I said the payoff from this project is both intellectual, this is fascinating. It's amazing. Just for the work I've already done preparing for this casebook. It's just, and I'm looking at cases from Cincinnati in 1869. It's absolutely fascinating. But so there's just sort of the scholarly interest. And there's, Jews are sort of a microcosm for so many issues. But then just the pragmatic, guess what? When we're done, we will know, we will have sort of synthesized, ideally, the universe of legal tools that are at our disposal to fight anti-Semitism, and to the people, that people who are out there, litigators and the community who are trying to figure out, okay, we've got this sort of problem. What do you have in the toolkit? And you think would work? We'd be able to give answers to that.
So there are a number of questions in the chat box. I'm going to raise a couple, and if people who ask them want to follow up, they could put themselves on mute. So let me first, there's a question from Patty Marcus to you about what non-Jewish groups are involved with your effort, if there are any, and if you could talk a little bit about that.
Well, let me start with the Indiana State Bar Association and with the Indianapolis Bar Association, which and the IU Division of Diversity, Equity, and Inclusion. I mean, these were organizations that we went to them. We said, we want to have this conference. And they said, let me grab my checkbook. They immediately understood why this was important. They didn't need to be, you don't need to be Jewish to understand this. We had law firms with, with their own diversity offices who, pushing lawyers, non-Jewish lawyers to take this. So it's not a hard sell. It's something that just needed to be pointed out because no one had pointed out before.
There was another question about, well, I guess let me start first with my question. When will your course first be offered? When will you start teaching the class?
Well, I mean, these things work in tandem. So, right now I'm working on the chapter on the Establishment Clause. So by the time I'm done, I'll have a syllabus for a unit in a First Amendment class on the Establishment Clause. I mean, so it's like it's producing an album, and you cut a song every certain number of months. So it's what we're hoping. I mean, look, the main resource that Diane and David and I have is time. So if we, so that's the only thing. That's what will make it go faster. That, and I think hiring research assistants. I mean,
Well, I think in relation to when the course will first be offered, knowing that this is a mixed group, right, of people who are mostly not academics, even a senior tenured member of the faculty can't put a course on the schedule by saying so, right? Things have to be approved by a curriculum committee, and the curriculum committee says, what casebook are you going to be teaching this from again? And where's the syllabus? Right? And a junior faculty member has absolutely no ability to do this, right? They could, if they wished, propose it. It might or might not get through. And even after it's approved by the curriculum committee, that doesn't put it on the schedule. Somewhere an associate dean has to put it on the schedule. And you have to get relief from the other classes you would ordinarily be teaching. You can offer to teach an overload and they can say, no, right? We're only going to let you teach 6 units and you teach federal income tax and wills and trusts. So glad you're interested in that, but no. So the process of getting it on a schedule, it's going to be a while before that breaks through. And that's why we're moving all of it forward at the same time, right? Will it be Rob or Professor Schraub or me who can first offer it? Will it be someone else of our acquaintance who is in a position, if they have enough of the materials and a syllabus, to offer it? Maybe. Will Professor Katz be able to devote half of the next religion and the law class to it? Maybe, right? It's that kind of a project, right? You can't do it just, even if we had the casebook in hand, that wouldn't mean we could offer it next semester, even if we wanted to. So it's just, this is one of the realities.
right. But one of the things that I was so eager to be invited to give this presentation is that we need to create. We've got the supply, right? Well, we need the demand. Like, we need people who are sophisticated, who can say, this is outrageous that this isn't being taught, that this is being involved in different, this is being ignored. And start calling up deans and saying, you need to, you need to have something like this. Maybe we need to, is there someone, or would you consider starting a center, for the study of this? I mean, that's what the people who are listening to this and watching this, that's what you are uniquely in a position to do that we are not. It's like, we can just work on a book. I mean, we pulled off this conference. We're going to pull off more of them. We're in these panel discussions. We can do CLE, but there's a limit to what 3 law professors can do on their own without unresourced.
Well, I can understand a little of it. I only serve as an adjunct, but I remember it took me a couple of years. I prepared a syllabus for a course, and finally they said it would be okay, and I was going to call it competition in regulated industries. And they said, well, you'd face some difficulty, but we had a course that we taught for years called regulated industries. If you don't mind using that title, we're okay. So yeah, I understand.
You understand.
Yeah. I did want to follow up on one question somebody had asked about whether some of what you want to cover will be available online. Could people, if they're individual lectures or maybe parts of seminars that are.
Well, I mean, this might be an opportune moment to say then, I mean, Diane and I are drafting a grant proposal for a syllabus project to do precisely this. Between now and when the casebook is available, to say like, oh, here's your provisional, assemble yourself syllabus for this course. And so this is, this is a project, to get, if it could be funded, we could provide this in the interim.
Skimming through. Here's a question from, it shows up as Lauren. Have you considered including a chapter and partial focus on K through 12 public schools?
Absolutely.
Providing curricula on anti-Semitism for ethnic studies courses or.
Oh, okay. I didn't see where that question was going. Actually, I'm doing that's what I'm working on right now, is the Establishment Clause and Bible and prayer in public schools. And then, so in terms of,
Right, for our purposes, whether Jewish studies or Middle Eastern studies should be included in ethnic studies. For example, in California, where it is not, right? California, which actually has ethnic studies requirements at the California State University level. Ethnic studies in California covers Hispanic, Latinx, African American, Asian, and Indigenous. It does not cover Jewish studies or any form of Middle Eastern studies. That was a hotly contested political dispute. And it's a good example. I've been chatting with some people in the chat box. What we will cover is that dispute. We will not be taking a side in that dispute in which we accuse everyone who disagrees with us of anti-Semitism. That is not what this project is, right? This project will be about the meaning of the debate about whether, for example, Jewish studies belongs in ethnic studies, given the history of ethnic studies, given the history of Jews in California or elsewhere, right? Our interest is in understanding the deeper motivations, the legal dimensions that are happening when those debates are happening, not resolving those debates by taking a side in them.
I think we will have added value because in the course of this project, we are becoming like forensic scientists of anti-Semitism and are able to detect it in places where it has never been detected before and be able to articulate where it is. And that's what I was saying. One of the things that's so fascinating about working on this project is like, oh my goodness, I had to read that case 10 times to figure out, where the anti-Semitism was seeping in. And it's there, like once you see it, it's right in your face. So we'll be able to contribute to these, to all these things, just by virtue of preparing the casebook.
It looks like there are a couple questions from Ms. Bookman and from Mr. Dancis. I don't know if you want, Mr. Ryder, if you want to have them unmute themselves in some
Yeah,
order.
if they'd like to do that. In the meantime, let me ask you a simple, really simple question. One of the questions is, do you have a website? And so you can put that in the chat box. But in the meantime, for those whose questions you just mentioned, you could take yourself off mute and pose them directly to Rob.
We have a website in progress. It hasn't gone fully operational, but if you just email us, me or Diane, we'll as soon as it's up and running, we'll let's put everyone.
So I see questions from let's see, Susan Bookman has her hand raised.
So is there a link to something on the web that I could send friends? Oops. Is there a link on the web that I could send friends to?
Not yet. Now,
Well-
what we will have soon, I mean, I have email addresses for us so if people want to get in touch with us. And the conference that took place at IU, its proceedings were mostly recorded, and we're now in, what we in Los Angeles would call post-production. But they will be available, and that will be connected to our website. So you can, as it were, kind of attend our conference virtually to hear the different kinds of things that people are working on under this umbrella.
One other question I have here is, will your casebook discuss anti-Semitism under international law?
So, well, I mean, the way that I've been getting at that was using American law to protect the rights of U.S. Jewish citizens in anti-Semitic countries. That's my first take on that angle. And the other angle we will get this is immigration, which was used notoriously to keep Jews out. And so immigration as a form of protecting Jews abroad by bringing them here. It's a very, so that's where we are right now. I mean, and then they're also indirectly, because the issues of like state law about Israel boycotts. I mean, that's another way that we get at international issues through the door of U.S. domestic law.
I have a question. This one caught my eye because my youngest son had gone to Cardozo to law school, but the suggestion is, would Cardozo be a good place to start presenting the material or finding other law schools with hospitable faculty? So that's a suggestion from Deborah Glazer.
Well, put me in touch with with the right person. I mean, or by the way, I mentioned Diane and I are going to be in Washington, March 16th, 17th, and 18th for the academic engagement. May. So we're available. People want to have coffee, to talk about any of these things. We'd love to. Academic Engagement Network was actually one of the first movers for our conference, and it's sponsored it. It's an amazing group.
Let's see if I'm sorry, I'm just trying to scroll through these. Why don't I just suggest here's an interesting one. Why did you call this Jews anti-Semitism in the law and not just anti-Semitism in the law?
Yeah, that's a great, because sometimes the anti-Semitism isn't obvious. Sometimes it's lurking in the background. Sometimes there are, it's internalized anti-Semitism. So for example, Jews distorting themselves in way, like willing to go to public schools where they're teaching the Bible and not complain about it. which is a form of internalized anti-Semitism, sort of Jews warping themselves to make themselves safer. So,
I think
yeah.
also, as I mentioned in the chat, our casebook is not only going to detail anti-Semitism, because anti-Semitism is not the be-all end-all of the legal construction of Jewish identity in the United States. When Jews use zoning law to create a yeshiva or to protect a community, that's not anti-Semitism, right? They may encounter some resistance that may have an anti-Semitic dimension, but that's not anti-Semitism, right? When we think about the use of free speech law to protect or to limit Jewish self-expression, right? That is, we want to be more inclusive than just to be identifying incident after incident of anti-Semitism. And there are sides, right? That is, law has been used as we say in some of our materials, both to combat and to perpetrate anti-Semitism. And so what we're really thinking about are those three poles, right? Law, Jewish identity in America, and anti-Semitism.
And that's why in my talk, I identified, the four themes are, pushing back on white Christian identity, equality, safety, and Jewish flourishing. Diane just mentioned one about zoning. Another one, which is public support for parochial education. That was famously opposed by leaders of the Reform movement starting in the 1860s, partly as a way of sticking it to the Orthodox, to sort of get the Jewish kids in public schools and to weaken orthodoxy. Well, so that's a debate over what constitutes Jewish flourishing in the United States. Is it public schools with supplemental Hebrew schools, or is it full-time day schools? That's a debate over Jewish flourishing, and that's not neatly captured under the heading of anti-Semitism. But it's part of what makes the field so fascinating.
Rob, let me, before I forget, mention that, if you're coming to Washington or going to be here in the future and you want to connect with faculty members, there's a number of law schools in the DC area, and the JCRC and Tzedek, have connections to some of them. Some are board members, have been on or on faculty of some of the schools. So, just touch base with us and maybe, there's some connections there.
Thank you. That's exactly what needs to happen for this to become a field. We need to have like a critical mass of law school faculty and deans saying, hey, we've got to, we've been missing out on something. We're gonna make this part of what we do.
Well,
Rob,
Hey, Rhonda.
I went to camp with Mark Katz.
I know that, Rhonda.
I know you do. And I see that there's a Mark there. So I wanted to say hello. And thank you so much.
That's my brother.
I know.
My sister is up here too somewhere. Okay.
Oh, hi. Thank you for all your work.
Well, I think we're running near the end of the program, Rob. I wanted to thank all of you for joining us today. We're going to have some upcoming programs, and we'll send notices about those out to everyone. But we really wanted to thank you and hope this has been a good chance for people to engage and to find out, what they can do. And you have Rob's email, I think, so you can contact him if you have some suggestions about, where you can help. So again, thanks everybody. Thanks for joining us today.
Thank you so much for inviting me. Thank you so much, everyone, for showing up.
And maybe next time in person, and we can actually give you a sandwich. That's something we used to do for the speakers. We give them a sandwich. Everyone else just got chips and cookies.
We'd love to get you a sandwich, Rob. And I want to add to Harvey's thanks to you and to Professor Klein for such a rich and meaningful presentation.
Thanks to both of you.